Raw story reported that the Supreme Court heard arguments in Moore v. Harper on Wednesday in a case that focused on the quote-unquote independent legislative theory. This is a theory that was part of the attempt to overturn the 2020 election results. The doctrine holds that the U.S. Constitution gives state legislatures, not governors or state judges, the full and exclusive authority to draw maps of congressional districts, even if that results in a lopsided advantage for their party. The lawmakers note that the Constitution says the rules for electing members of Congress, quote, shall be prescribed in each state by the legislature thereof. This is a very literal interpretation of this. Before we continue on here, we need to say why that quote is there. That quote is there to prevent the federal government from telling the states how to draw their maps directly at the time that the Constitution was written. Also, it was under the assumption that each state would be better able to, under its direction, to draw those lines. Makes perfect sense. It isn't there, going back to originalism, fucking funny how that works, okay? It isn't there to prevent a state from determining in its own constitutional authority how those lines are drawn. It isn't there to literally mean only the state legislature can draw these lines. This theory is not grounded in any basis of reality. You can fight me on this all you want. That is my opinion, and that is where the facts are here. But we have to continue on because we have to give this the full weight that it deserves in order to understand it better. But that's where it is. This is not based in actual legal theory. It is a legal solution to a problem, and that problem is Republicans not winning all the time. The GOP argued that because the word legislature is in the U.S. Constitution, it elevates state legislatures above the constraints of their own state laws for this purpose. But no one, original or otherwise, even entertained that idea. Lawyers representing the Democratic Party and voters in North Carolina called the theory radical and said it would overturn basic principles of checks and balances, because it would. The reason this is being pushed is because due to big data gerrymandering in 2010, Republicans have a baked-in advantage in many states on the legislature, but they don't have that same advantage on statewide elective offices. So what they're trying, or the courts for that matter, because the courts have to follow their constitutions, and their constitutions sometimes get amended directly by the voters. So all this is being done in order for Republican legislatures to circumvent the will of their people and their own state constitution in order to gain political advantage. This is flying in the face of liberalism and spitting in its face. It is spitting in your face. It's thinking that you're stupid enough to believe that this is something that's actually true. Don't let them do this. Over the course of a 3-hour oral arguments, the justices peppered both sides with questions. Justice Ketanji Brown Jackson obviously had a problem with the idea of excluding a state's executive and judicial branches from governing elections. The Biden appointee told her colleagues, quote, I guess I don't understand how you can cut the state's constitution out of the equation when it is giving the state legislature authority to exercise its legislative power. It's a pertinent question. If the state's constitutions create state legislatures, then how can state legislators violate state constitutions? A number of conservative legal experts filed briefs in Moore v. Harper opposing it, including Thomas Griffith, a former judge appointed by George W. Bush, J. Michael Luttig, a former judge appointed by George H.W. Bush, Stephen Calbazizi, a co-founder of the Federalist Society, Ben Greensberg, a renowned GOP election lawyer, and Charles Fried, Ronald Reagan's Solicitor General. And in an unprecedented move, the chief justices of all 50 states' Supreme Courts, that means each state's Supreme Court's chief justice, the person serving on the bench, is urging the SCOTUS not to adopt the theory for fear of confusion and mayhem at every level of the judiciary. We'll close coverage of this case with analysis from Democracy Docket's prominent voting rights attorney, Mark Illes. Illes writes, quote, one of the big questions I had before the argument was how broadly the Moore lawyer would argue the case. And he went very broad, arguing from the start that there can't be a limit on the state legislative power to regulate congressional elections because it's a federal function. In practice, that would mean that the state courts could not strike down state laws pertaining to federal elections for violating their state's constitutions. In retrospect, this decision by the Moore lawyer to take an absolutist position against state court review may well prove to be a mistake. If the court's ultimate opinion follows the trajectory of the argument, future voting cases would face additional steps in the legal process, but little more. State court election law decisions would be subject to an additional question. Did the opinion fairly reflect state law and the state constitution? While this would create new vehicles to attack pro-democracy court decisions, in practice, it would more likely lead to longer, more carefully written state court decisions rather than to change the outcome of many of these cases. Significantly, Justice Brett Kavanaugh and Amy Coney Barrett expressed similar skepticism. Even Justice Clarence Thomas, usually a stalwart conservative, asked tough questions of Moore's lawyer. One of the more striking takeaways from the arguments was how little even the most conservative justices came to the Moore's lawyer's defense. Notably, while Justice Samuel Alito support for the Moore's party's position, even he expressed some reservations. In the 3-hour argument, it was only Justice Neil Gorsuch who seemed entirely comfortable with Moore lawyer's arguments. Most importantly, as the argument wore on, there was an increased focus on the concurrence in Bush v. Gore. In that case, 3 justices wrote, quote, "Though we generally defer to state courts on the interpretation of state law, there are of course areas in which the Constitution requires this court to undertake an independent, if still deferential, analysis of state law." In a sign of potential consensus, by the end of the arguments, even Thomas and Alito were asking questions about how such a test would even work. Whether or not they signed onto a middle-of-the-road opinion, it clearly was where the center of the court was at the close of arguments today. One, we can hope, because if this were to pass, if Moore v. Harper is to go in favor of the plaintiff, in favor of the independent state legislature, it blows out every single law that the constitution of each court, of each state does in terms of voting, of anything voting related. It gets rid of the constitutional court's ability to redistrict lines based on based on constitutional concerns, state, federal, or state. It gets rid of their ability to impose maps to rectify any conflict to make an election fair. Not just conflict about between the law, but between the legislature. So if they have multiple maps, then this would not allow the court to pick one. So they could be in limbo and have to continue with previous maps that existed 10 years prior. There's a lot of things that this can mess up. It can also mess up any ballot initiatives that do things like implement instant runoff voting, because that didn't come from the state legislature. So this would muck up a lot of things. And again, it is not based on anything grounded in legal theory. It is a literalist interpretation of a single sentence within the Constitution, written to give states to tell states that they have their legislature are what determines voting lines. There's something that's interesting about this. There's nothing preventing the Supreme Court from ruling in other ways that mess up other things with this decision. While they can knock down the independent state legislature thing, they can say, well, this will get rid of the entire Voting Rights Act, for example. Any map that is in congruence with congressional law over states' congressional maps is null and void because this sentence is in there. That's a possibility. Not one that I've seen many people bring up, so remember that.